Welcome to Walking Through the Federalist Debates. I'm Jacob Hibbert of the New Guards.
And I'm Richie Angel.
We are really excited to be with you today. We are going to be walking through the preamble to the Constitution and Article 1, the longest and largest article of the Constitution. And we're really glad that you're joining us today. So as you'll see through these videos that we do, as we walk through the Constitution, we'll be reading it word for word and making comments, sharing insights that we have as we go through it. So we'll be starting off with the preamble. Richie, do you want to start us off with the preamble?
Absolutely. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America.
So what I like about the preamble is that sometimes people like to separate the Constitution on one hand and the Declaration of Independence on the other hand. And like there was two foundings, like these two documents are two completely different things. And if you look at the Constitution and you look at the Declaration of Independence, they are actually incredibly intertwined. In the Declaration of Independence, we are told by Thomas Jefferson that the purpose of government, that men create institute governments to secure their rights to life, liberty, and property. When you look at the preamble that Richie just read, it gives us a list of reasons why they're establishing this Constitution. You know, to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, to secure the blessings of liberty. All of these things that the Constitution is supposed to do fall perfectly or beautifully under the purpose of government as outlined in the Declaration of Independence. Providing the common defense is protecting your rights from foreign invaders. Having domestic tranquility, keeping law and order, is protecting your rights from internal threats or from conflicts of rights that occur in everyday life. Promoting the general welfare and securing liberty, that's all protecting rights. And so the purpose of the Constitution, as we read here, is the same purpose as what we see in the Declaration of Independence, to secure liberty or rights for the American people now and for generations.
All right, sounds good. Jacob, would you like to take the next part?
Yeah, so now we're going to go into Article 1. Article 1 is the article that details the role and responsibilities and limitations of the legislative branch. So Article 1, Section 1 reads, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives.
I'm going to stop you there really quick. I promise we won't do this every single sentence as we read the Constitution, but this sentence is one of the most crucial in the Constitution and has been one of the most ignored, which I would then attribute to some of the greatest damages that have come through this country, is not understanding and applying this sentence. I'll read it again. All legislative powers herein granted shall be vested in a Congress of the United States. All legislative powers herein granted. That means that all lawmaking powers are given to Congress. All of the authority to write, create, pass laws go to the Congress of the United States. Presidents do not make laws. They sign laws, but they do not create laws out of whole cloth. The judiciary does not have the power to make laws. All powers herein granted by the Constitution are vested in a Congress of the United States. And right now, that authority is not being exercised and is not being limited to the Congress, which is why we're seeing executive overreach. It's why we're seeing judicial overreach. It is because of a lack of respect for the first sentence of the Constitution after the preamble. The first sentence of Article 1, completely thrown by the wayside.
And I also add in there, administrative law. The fact that administrative law exists is testament to the problem that you're talking about, that law-making abilities not being taken from Congress and invested in executive bureaucracies that aren't elected by the people. Another comment I want to make real quickly about this sentence is, you know, it seems very straightforward. Okay, so we're going to have a Senate and a House of Representatives. That was a huge point of conflict during the framing of the Constitution, whether or not we should have a Senate, whether it should just be a House of Representatives, whether they needed to have there was a lot of different plans that were supported or that were supported or presented at the Constitution. And what we see here is a compromise that was made that created a Senate that would represent the states and a House of Representatives that would have represent the people, or more of that popular democracy kind of feel. So while this seems very straightforward, and for us who have grown up in the United States under the Constitution, it's like, well, of course, Senate and House. This line here represents what was a great battle in the framing and a huge compromise made between the small states and the larger states. Moving on to Section 2. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. No person shall be a representative who shall not have attained to the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Representatives and direct taxes shall be apportioned among the several states, which may be included within this union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. So that's the infamous 3/5 clause, the 3/5 compromise. Where
we should probably pause there to explain that a little bit. Oh, yeah. I'm sorry if you were
go ahead.
Into that. Okay, so 2 notes on that. First of all, as you'll read in most constitutions, will give you these kinds of footnotes, that section about the 3/5 compromise has been changed by Section 2 of the 14th Amendment. So that's no longer part of the Constitution, but we still read it in its entirety. But the more important note here is that the 3/5 compromise was actually a measure against slavery. There were a lot of people in the Constitutional Convention from differing cultures within the United States, and they had a lot of different interests, and they had to compromise on certain things in order to form that more perfect union. That was a more pressing need at the time than there were certain things that they had to lay aside to just deal with later. Slavery was one of those things. They needed a country, and then they could abolish slavery down the road. But the reason that the 3/5 compromise was introduced was not to prolong slavery. It was, in fact, to cut at it, because what the South wanted to do was to, as we're talking about, the direct proportionment or apportionment of the House of Representatives, that according to your population, that's how much or how many representatives you'll have in the House, and thus how much power you will have in government. The South wanted to count all of their slaves in the population in order to gain more representatives. And with all of the slaves in the South, those numbers were going to be astronomical. This would give the South tremendous power in Congress and create a roadblock around abolishing slavery. It was going to enshrine slavery if they were allowed to do this. Now, northern states pointed this out. They mockingly said, well, we're going to throw in all of our chairs and tables and everything else in our house because you're counting what you call property as your population. So we're going to count our property as our population. And so they eventually whittled it down to this 3/5 compromise so that the South would agree to join in the Union. They would still have some representation for that slave population, but it would be much smaller and thus much easier to abolish slavery down the road.
Essentially forcing the South, basically saying you can't have your cake and eat it too. If you're going to treat these people like they're not full human beings, then we're not going to count them as full human beings in voting. Another thing that's interesting from this clause is where it talks about direct taxes are apportioned to the several states. So taxation on a federal level was handled by the states, where it was the state's job to raise a certain amount of money in proportion to the amount of citizens they had. So if you had a really populous state, it was the job of that state to get the requisite proportion of taxes needed to fund the legitimate functions of government. It was the state's job to make sure that that money was made available. Continuing on, the actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least one representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to just 3, Massachusetts 8. What was that?
To choose 3.
Choose
it's
3.
A weird spelling. Choose 3.
Yeah, it's a very weird spelling. Massachusetts 8, Rhode Island and Providence Plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. When vacancies happen in the representation from any state, the executive authority thereof, so in this case the governor, sometimes they would have a president of the colony or of the state, but now would be what we'd call the governor, thereof shall issue writs of election to fill such vacancies. The House of Representatives shall choose their speaker and other officers, and shall have the sole power of impeachment. All right.
Any notes there?
I think it's important to recognize that the impeachment power is given to the House of Representatives. And when we recognize that the House of Representatives is supposed to be the representatives of the people as a whole, it reiterates that in the American experiment, power in the ultimate sense resides in the people. How that power is exercised is through representatives, but the fact that the people's body is the source of taxation, is the source of the purse, is the source of impeachment power, just reiterates that when it comes to the general government into some functions, the power is ultimately in the people, and it's up to them to exercise their power through the representatives to get their desired outcomes.
All right, so moving on to Section 3, now we're going to talk about the Senate. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof, which has been changed by the 17th Amendment. Now it's a direct vote, a popular vote for senators, just like it is for representatives, for 6 years, and each senator shall have 1 vote. Immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the second year, of the second class at the expiration of the 4th year, and of the third class at the expiration of the 6th year, so that 1/3 may be chosen every second year. And if vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. Again, that is changed by the 17th Amendment, which I think we should talk about pretty quickly here. Like Jacob was saying earlier, this whole idea of a Senate and a House of Representatives, this compromise was revolutionary. This had never been seen before, and it was a tremendous compromise to allow the people directly to have a say over the government, to have that check and balance, but also for the states to have a vested interest and a check and a balance over the national government. The 17th Amendment here, changing this language from the Constitution, essentially made the Senate and the House of Representatives the exact same thing. They have the exact same purpose. They are directly voted upon by the people. They are there to represent the people and not the states. They have the same role. The only difference is how many there are from each state and how we decide how many there are from each state. But their role in Congress is now exactly the same, and it has gutted the purpose of that bilateral Congress.
Exactly right. The beauty of the Constitution as framed by the founders was that everyone had a seat at the table, in the sense that the states had a seat at the table and the people had a seat at the table. With the passage of the 17th Amendment, the states no longer had a seat at the table. And when you look at the powers and the things that are given to the Senate in particular, often, as you'll see, most of their powers relate to foreign policy, to going to war, things that have to do with external relations. And that's due to the fact that the states as a whole, previously, the states were conducting their own foreign policy. They had their own trade agreements. They had all of these, individual things that they could do. They were treated like separate countries. And so they gave the federal government that the powers and abilities that they had to act as separate countries to the new union. And so the Senate focuses on things that affect the country as a whole. Now that comes from the state governments, not from the people. And like Richie said, that's been distorted by the 17th Amendment.
Right. So moving on here, no person shall be a senator who shall not have attained to the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. The Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. The Senate shall choose their other officers, and also a President pro tempore, in the absence of a Vice President, or when he shall exercise the office of President of the United States. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside. And no person shall be convicted without the concurrence of 2/3 of the members present. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law.
Now, this is important to note that to impeach someone happens strictly in the House, and then the trial, the enforcement of that impeachment, takes place in the Senate with the chief judge presiding, and 2/3 have to be present to ratify, I guess you could say, that impeachment. And then after that, that's the only power that the Senate or and Congress have to affect the individual who's been impeached. If there are crimes or things that have occurred, those are tried later in a normal criminal trial. Like it says that impeachment shall not extend further than removal of office. That's all it will do. But if there are going to be further punishments there were crimes that need to be punished, those will occur in criminal or civil courts after the impeachment.
Mm-hmm. And we don't want to step on too many current events or anything controversial, but just to bring up that there is a discussion right now, and in politics in general, it's been going on for decades, about whether legally you can criminally indict a sitting president. And constitutionally, that comes up in that last sentence there. Again, not taking a side here, but where it separates what the Senate can do in an impeachment trial, and then that party convicted can be indicted. Does that mean they can only be indicted after they've been convicted and are no longer president, or can they be indicted by a separate body previous to that? That's kind of where that debate arises.
All right, Section 4. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. The Congress shall assemble at least once in every year, and such meetings shall be on the first Monday in December, unless they shall by law appoint a different day, which they have. Usually the first meeting of Congress happens in January now. Section 5. Each house shall be the judge of the elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business. But a smaller number may adjourn from day to day, and may be authorized to compel the attendance of absent members, in such manner and under such penalties as each house may provide. Each house may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3, expel a member. Each house shall keep a journal of its proceedings, and from time to time publish the same, excepting such parts as may in their judgment require secrecy, and the yeas and nays of the members of each house on any question shall, at desire of 1/5 of those present, be entered on the journal. Neither house, during the session of Congress, shall, without the consent of the other, adjourn for more than 3 days, nor to any place than that in which the two houses shall be sitting. Any comments or anything you want to add to that? I think it's pretty straightforward.
Yeah, I agree. I think it's interesting they mentioned that with the concurrence of 2/3, they can expel a member, which is almost like an impeachment within themselves. It's an inter-impeachment where they don't need both houses to go through or both chambers to go through it, but just with a 2/3 vote themselves, they can expel a member of Congress. All right, Section 6. Oh, sorry, did you have something?
I was going to invite you to go ahead.
Okay. Section 6. The senators and representatives shall receive a compensation for their services, to be ascertained by law and paid out of the Treasury of the United States. They shall, in all cases, except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning from the same. And for any speech or debate in either house, they shall not be questioned in any other place. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time. And no person holding any office under the United States shall be a member of either house during his continuance in office. All bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as on other bills. Every bill which shall have passed the House of Representatives and the Senate shall, before it becomes a law, be presented to the President of the United States. If he approve, he shall sign it, but if not, he shall return it, with his objections to that House in which it shall have originated, who shall enter the objections at large on their journal, and proceed to reconsider it. If after such reconsideration 2/3 of that House shall agree to pass the bill, it shall be sent, together with the objections, to the other House, by which it shall likewise be considered, and, if approved by 2/3 of that House, it shall become a law. But in all such cases, the votes of both Houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each House, respectively. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law, in like manner as if he had signed it, unless the Congress by their adjournment prevent its return, in which case it shall not be a law. I think
it's important to make some comments here on this section about the veto power. And that's what we've just read, is essentially the veto power and how that interacts with the powers of Congress. Some people think that when the Constitution here says that if he shall approve, he shall sign; if he shall not, he shall return it with his objections to the House. This is not willy-nilly objections, in the sense that I suppose you could make the argument that these are for if you don't like specific details. But this is one of the important ways that the president is exercising his duty to uphold the Constitution. His objections should be based on the constitutionality of the bill that is on his desk. So when we talk about checks and balances, erringly, a lot of people see the Supreme Court as the protector of the Constitution. Under the original Constitution, and as we'll see as we go through the Constitution, every branch has a role and responsibility to uphold the Constitution. And the veto power is one of the ways that the president upholds the Constitution, by not signing bills that are unconstitutional. Those objections that he would submit would be reasons why the bill is not constitutional. And so everyone has that responsibility to keep Congress and any act of the federal government, to keep it under check according to the Constitution.
And another important part of that veto, especially as we're going to see with the judiciary, as Jacob was talking about, and that their role in defending the Constitution, there was no one branch set up to be the final word on the Constitution. They are meant to check and balance each other continuously, and a matter is never settled. So when Congress passes a bill, each house has to agree to this bill. So they're balancing and checking each other. Then the president checks and balances Congress by determining whether to veto or to raise objections. And then Congress checks and balances the president, and if they have 2/3, can override it. Now, if the people then don't like what their representatives are doing, if they agree with the president that these bills should not be passed, then they have the power to vote out those representatives. And at least during the time of the ratification, the states also, if the states did not like what their representatives in the Senate were doing, they could remove them through other means.
And the checks
Everyone
and
is
balances,
checking.
the checks and balances you mentioned and within the Congress is the interests of the states represented by their senators are checking and balancing against the people, and the people's interests are checking and balancing against the interests of the states. It's this beautiful interlocking system. It's kind of like a clock where when you open it up and you see all the gears moving and interacting with each other, it can look almost messy, but when you start to understand what's happening here, it's a beautiful system of interests and representation and checks and balances working together to fulfill that ultimate purpose of government, like we talked about at the beginning, securing the freedoms and liberty of the American people.
Much better than just telling a handful of people who may or may not be wearing black robes, what does this sentence of the Constitution mean? They tell us what they think it means, and that's our interpretation forever. That is not what the Constitution had in mind. We need that interwoven, nuanced approach. So just to finish
that's how you protect liberty.
Yep. So just to finish out Section 7 here, every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill. So just more detailed stuff.
All right, now we get into Section 8, which is where we have the enumerated powers of Congress given. Now, this enumeration is meant to be a finite list. This is what Congress can do. And as we'll see later in the Constitution, there are phrases such as necessary and proper or promote the general welfare, things like that that have been used and interpreted to mean powers beyond the enumerated powers. But James Madison, when he's writing about this section and responding to that view of those clauses, said that promoting the general welfare is the enumerated powers, that these powers we were about to read are how you do that. This is what Congress is authorized to do and no further. So let's start reading those. The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. The general welfare being protecting the rights of citizens. But all duties, imposts, and excises shall be uniform throughout the United States. 2, to borrow money on the credit of the United States, to regulate commerce with foreign nations and among the several states and with the Indian tribes. This is a big change from the Articles of Confederation, which treated the several states as individual, as in states or as separate countries. What this does is saying, when it comes to commerce between the states, me living in Virginia, if I want to do business with Richie in California, the laws that Congress established is going to make sure that that functions properly. And when it says regulate, it doesn't mean regulate in the same way that we think of regulation today. Regulation today is often thought of laws and restrictions on certain behaviors or activities. Regulate at the time of the founding meant to function properly. Clocks at this time had what were called regulators, which made sure that which kept the clock functioning. And so to keep the commerce between the citizens in the United States, between the states, and to keep the ability of me to buy and sell from foreign countries and foreign businesses and foreign individuals, to keep that functioning properly, to keep it running, to allow it to happen, really, Congress has the power to open up that trade between the states and with foreign countries. It's not a restrictive power, it's an opening power. To establish a uniform rule of naturalization and uniform laws on the subjects of bankruptcies throughout the United States. Here we see that Congress has the power to determine who can become citizens of the United States. Congress is where the power lies to determine issues of immigration, status, all of those things. The executive branch or the judiciary or any of the federal courts beneath the Supreme Court do not have that power. It is vested solely in Congress. To coin money, regulate the value thereof and of foreign coin, and fix the standard of weights and measures. To provide for the punishment of counterfeiting the securities and current coin of the United States. to establish post offices and post roads. Richie, what's a post road?
Post road, it can be interpreted in a couple different ways, but traditionally, as the founders intended it, when they talked about Congress having the authority to create roads, these were for the purpose of government use, primarily so that they could promote the general welfare. So in talking about post offices, they're talking about communications happening between the states. So these post roads are created so that communications can flow between the states. It's almost a mini version of necessary and proper, a more specific version of necessary and proper within this statement. The military needed to have roads to get from one state to another. The police need to have roads.
To another.
Exactly. Police need to have that ability as well to travel the roads. You and I get to travel the roads as a courtesy, but the purpose of roads is for government agents to be able to travel them to ensure that our rights are being protected.
And so the roads that were being built were built exactly for that purpose. It wasn't for our convenience. When the government built a road, it was because the military or communications within the Union for it to protect our rights needed to be built. I can't protect your rights if I can't get to you, kind of a thing. And so,
which is why you still see today that the government has the superior control over the roads. If an ambulance turns on its lights and sirens, you pull over. If a police officer turns on the lights, you pull over, even if it's just for them to get past you. I'm not talking about them deterring you. If they need to use the road for a government purpose, then they have control over it, and you better get out of the way because it is their road. That's the purpose of the road.
Because the purpose of the road is to protect your rights. This is all this is all an outflow of government protecting your rights, not telling you how to live, not seizing power. It's so that you can be protected and to enjoy your freedoms and pursue happiness.
Exactly.
To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So getting patents so people have an incentive to try to invent things and their intellectual property can be protected. To constitute tribunals inferior to the Supreme Court. So every court that exists, every federal court that exists in the United States that's not the Supreme Court is a creation of Congress and subject to Congress as well. So if there's a federal court in some part of the United States that makes a ruling that is unconstitutional, Congress has the power to eliminate that court. They can just say, well, you just don't exist anymore, or to ignore or override that court ruling because that court is a creation of Congress. The creation cannot surpass the creator, and in this case, the creator is Congress. To define and punish piracies and felonies committed on the high seas and offenses against the law of nations, to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water, to raise and support armies, but no appropriation of money to that use shall be for longer term than 2 years, to provide and maintain a navy, to make rules for the government and regulation of the land and naval forces, to provide for calling forth the militia to execute laws of the Union, suppress insurrections and repel invasions. So Congress can declare martial law or call out the military or the National Guard or the militias to create law and order. That's not a power given to other branches of the government. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectfully the appointment of the officers and the authority of the training the militia according to the discipline prescribed by Congress, to exercise exclusive legislation in all cases whatsoever over such district, not excluding 10 miles square, as may, by session of particular states, and the acceptance of Congress, become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state, in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Congress in the government of the United States, or in any department or officer thereof. That line, necessary and proper, is often called the necessary and proper clause. Richie, what's the correct understanding of the necessary and proper clause? What does that mean?
The Constitution could not properly or reasonably be expected to detail every single aspect of how Congress was going to do its job. It gave them certain enumerated powers, but it wasn't going to tell them exactly what kind of committees they needed to form and exactly what kind of currency it was going to be and how they were going to determine that and how they were going to get the money out to everyone so that everyone would have a common currency, all of those sorts of things. The necessary and proper clause means that within the scope of the Constitution, you can do what is necessary, what is proper, what is appropriate for you to ensure that your duties are able to, or that you are able to fulfill your duties. Again, all for the common defense, for the general welfare, to secure your rights. So if Congress needs to do something in order to establish that army or that navy, or to regulate that commerce between the states or between foreign nations, then it can do it doesn't the Constitution does not detail how they are to go about that. It simply states you do whatever you have to, so long as it is within the functionality of the Constitution, the limits of the Constitution, in order to secure those rights.
It's not a blank check. It's to say it's within the confines of these specific powers. You do what you can do things to execute that role, but it doesn't mean you can establish anything you want because it's necessary and proper in your opinion. So it's both an enabling clause, but it's within the confines of very strict enumerated powers.
I would like to hearken back to one line that's in Section 4 of Article 1, Section 4, Clause 3, where it's talking about the journal of the proceedings, publishing those parts, except those parts as may in their judgment require secrecy. Now, there's a difference between the phrasing of as may in their judgment require and shall be necessary. That is a higher standard for the necessary and proper clause than it is for determining which parts of their journal should be published. When it says in their judgment require, it's saying that the members of Congress can decide, do they think this is necessary? But when something is actually necessary versus what do these politicians think is necessary or might argue is necessary, it is a much higher bar to say this is necessary that we do it in order to secure your rights. So I just wanted to point that out, that they phrased those two things very differently, and yet we treat the latter as if it is the lighter standard of the former, according to the judgment of Congress. Whatever they want to do, that is necessary.
That's awesome insight. Do you want to take Section 9?
I would love to. Section 9, now we get into the powers forbidden to Congress. The migration or importation of such persons as any of the states now existing shall think proper to admit, in other words, slaves, shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. And I'll just say briefly, and Jacob, if you want to add anything, this is another compromise, yet measure designed to gradually, over time, abolish slavery. They did not envision from the outset of the Constitution that they would have to fight a bloody war over the institution of slavery. They hoped that they could gradually sift it out, as was done in the state of New York, for example, with great success, over time through gradual progressive steps. So here, they cut off slave importation in the year 1808. There were about 20 years where you could still import slaves, but that importation could be heavily taxed if states desired it. And so all of this was just a measure to gradually cut out that institution. These are not things that promote slavery, that excuse slavery. These were difficult compromises, but they had to be done in order to gradually quash out this institution that was not going anywhere in a hurry.
No, that's fantastic.
So moving on, the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. We'll touch on this more when we get to Article 4 of the Constitution, so I'll save most of my commentary for then. But briefly, the writ of habeas corpus is simply that you have a right, if you are accused of a crime, to appear before a judge. You have a right to hear the charges against you. You have a right to defend yourself, all of those sorts of things. You cannot be imprisoned indefinitely without being sentenced. You cannot be imprisoned indefinitely without having a trial. That's what the writ of habeas corpus means. Habeas corpus, Latin for you must have the body. Now, the writ of habeas corpus can be suspended in cases of rebellion or invasion in the name of protecting the public safety, but we'll discuss that a little bit more later on.
Protecting the rights of the individuals in the country.
Mm-hmm. No bill of attainder or ex post facto law shall be passed. So you can't do something now and then Congress decides to make it illegal later and you're punished for what you did before it was illegal. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. Now, this is changed by the 16th Amendment. It's basically removed by the 16th Amendment. You could not tax people directly with an individual. The federal government, exactly. The Constitution is all about what the federal government can and cannot do. So the federal government could not directly tax individuals. So you could not have an income tax unless they said to the states, get this amount of taxes or whatever we need. And the state decided that's best done through an income tax. But the federal government could not levy an income tax until the 16th Amendment. No tax or duty shall be laid on articles exported from any state. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. No money shall be...
problem under the Articles of Confederation. Under the Articles of Confederation, the states were essentially engaging in trade wars with each other, putting tariffs and duties on ships from Maryland going into Virginia or from Georgia into Massachusetts. And this was leading, these trade wars were leading to the point where it looked like actual conflict was going to break out among the states. And so essentially the Constitution here creates a free trade zone within the United States for the states and the citizens interacting with each other. And so you can see this is direct responses to the weaknesses of the Articles of Confederation and the issues that they were seeing at this moment.
All in order to form a more perfect union. United States. It's such a simple name that we're so used to, but it is profound in its meaning. United States, separate bodies, united in the same country under the same umbrella of freedom. We treat each other as brothers and sisters. We can have loyalty to those states. Those states pass different laws, maybe even have different cultures, but we are united as one. We don't treat each other as foreign entities.
Exactly.
No money shall be drawn from the treasury, but in consequence of appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state.
And that leads us to the last section of Article 1. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or a law impairing the obligation of contracts, or grant any title of nobility. No state shall, without the consent of the Congress, lay any imposts or duties or imports or exports except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded or in such imminent danger as will not admit of delay. So once again, this is the states surrendering their powers that they exercise, their sovereignty as separate countries or separate states. This is them ceding that power officially to Congress and to the federal government.
that monopoly of force vested in the national government. And of course, checks existing between states and the federal government checking the states and the states checking the federal government. But in order for a nation to function, it needs to have the power vested in it by the states to protect the nation. I also love the first line of Section 10 for a very different reason. No state shall enter into any treaty, alliance, or confederation. We're not going to get too much into the Civil War here, but when the southern states declared their separation from the Union, they formed a confederation directly in spite of that line from Section 10 saying, oh, well, we can't do that, just watch us do that. We couldn't do it under the Constitution. Well, now we're a separate country. We can do whatever we want. It was all in reference to that line from Section 10 that they called themselves the Confederate States of America.
Awesome. Well, folks, that is the Preamble and Article 1 of the Constitution. We thank you for joining us and look forward to seeing you in Article 2.